Welcome to our Introduction to Trust course. This is Module 1, and we're going to cover a topic that is very important for all financial planners. In fact, it might be the best tool you have because it can be used for you becoming a financial advisor for a trust. You could be a trustee, or you could use a trust or mini trust in your financial plans. The problem, however, it's legalistic. Like insurance contracts, there's a lot of detail that you have to know, and therefore we'll have more information on the slide than we generally have. So just bear with me while we get to the next slide, which is our objectives. In this session, we're going to describe what is needed to create a trust, the roles of the grantor and the trustee, how we can use a trust, some dangers caused by the grantor trust rule, which is being watched very closely by the IRS, and we'll describe the basic duties of a trustee. What is a trust? It's actually something that's been around for thousands of years. We have used it in our society for personal financial planning since the 1960s, so it's a really new law for us. But in Europe, it's called the Usufruct, very similar. Up until the 1960s, in the United States, it was used for corporations, and you've all heard of the antitrust laws. And I would say the biggest advantage to it is that present and future interests can be separated, as well as legal and beneficial title can be separated. And these, I might note, as at the bottom there it says it becomes a legal entity when it becomes an irrevocable trust, which has a lot of ramifications and is probably going to be the main emphasis of this course. Why a trust? First of all, it provides for control of assets in case of incapacity, such as for older people or, let's face it, children under the age of majority. You cannot give an asset to a 5-year-old or to a person who is senile. The trust is the perfect place to give the asset. Protects dependents with special needs. I can set up a trust for a crippled child. Depending on the language, we can really reduce or eliminate taxes and provide protection from divorce settlements and creditors. This would be with primarily the irrevocable trust. We can be used to care for minor children by use of a guardianship. That would also require a will, but certainly the financial aspects can be covered in a trust. And it can be used to own and manage a business. And there are many large businesses in the country that are owned by trust. We can manage assets after death with a pourable will. That is a great idea because many times people inherit assets. They either don't have the maturity financially, or they may be under the age of majority. Again, they may also be mental incapacities, and therefore they need someone controlling the assets, and that's done with a trust. It's used as a will substitute to avoid probate and publicity. We can control the assets during lifetime by titling it as a part of a trust, and we provide for relatives and beneficiaries who are financially deficient, which is again a really protection for the beneficiaries. And then finally, we use it for real estate outside the state of domicile to avoid secondary probates. What is a trust? A revocable trust is a tool to control assets and be a will substitute. Testamentary trusts take effect at death, and our most common type is our pour-over trust clause in a will that takes the assets of the will, puts it in a trust at the end of probate, and managed by a trustee. An irrevocable trust is a gift, and the donor gives up complete control. In a revocable trust, the grantor has complete control during their lifetime. It's at death where they can't change it. But an irrevocable trust, it changes immediately as soon as it's made irrevocable. It's a taxable event. The owner has no more assets in it. It gets a tax ID, and all of a sudden financial responsibilities show up. A grantor trust means the grantor retains some controls or powers in irrevocable trust that results in being taxed to the grantor, although the income goes to the beneficiaries. That could be intentional, or it could be unintentional. Both occur. Elements of a trust: we have a trustor, we have a trustee, we have beneficiaries. Again, we can split the present and future interest. If we have a funded trust, we have an asset in it. And the asset is also called a race or assets. most trusts are funded, although you will find unfunded trusts set up by lawyers, so you can add the assets later on. For example, let's say someone 21 years old comes in, no financial responsibilities, no beneficiaries. You might want to, or she might want to have a trust set up so that when this situation comes up, they can put the assets in. The duties of trustee are not a requirement for a trust. However, a trustee would be able to do anything, would not be able to do anything without duties called out. And many times you have to go to court to get the duties clarified. And so I always recommend that you double check. First of all, you have a lawyer prepare the trust. Then you go to a trust company or a bank trust department and have validate that, yes, indeed, they would be able to manage that trust. The reason is the lawyer is concerned about the legal aspects. The trust company is the implementation or management of the trust. So you get the benefits of both. And then you can be a good trustee or turn it over to someone else to be trustee. Many times I've had clients come to my office with a trust. I said, have you checked it with a trust department to see if it's useful? If they didn't, usually I do it for them. And we find out what's deficient. Again, legally it meets the requirements, but how, in implementation, how do you do it? Anyone who's an adult under state law can generally create a trust. Some persons can be present in future interest, such as the income, as a minor getting income till the age of majority and then receives the corpus. Or it might be where they get the income today, they get part of the corpus at 25 and part at 35. Basic principles that the terms of a trust will ordinarily govern the authority and duties of the trustee to the extent the terms are possible and legal. Terms may be restrictive, they may forbid an otherwise proper activity of the trustee. In other words, the trust terms are very important, and that's again where you need to talk to someone who's an expert on it, such as a trust company or a trust department of a bank. They are very helpful, and they do this for free. I guess they hope that they can become a co-trustee, which is not a bad idea in many cases. Trust terms can expand the trustee's authority, permitting action that is generally considered improper for a trustee. And so you might have the trustee doing tasks that ordinarily trustees don't do. That can be done. Terms of trust are important for trustee to understand and follow diligently, since they control, except for limited cases where state law supersedes, and what they cannot be relieved of is the responsibility to exercise care, exercise skill, and exercise caution. Those must be in every trust. Anything else we can take out of the trust from the general rules, or we can add so much in, unless again it's impacted by state law. But again, you cannot take away the responsibility of the trustee to be exercise due care, skill, and caution. Those are key words in any trust situation. And we're going to spend some time on that, obviously. Length of time, trust for charities may last forever. However, if they're for individuals, we have to be subject to rules against perpetuity, which is a limited time period you can have a trust alive. The exception is the dynasty trust, which is also known as the Alaskan trust. A lot of literature on that today. Many lawyers are using it because we can get away with the need for the time period in the trust. So you can have it for many generations. In fact, it gets around the many taxes. It also gets around the generation skipping tax. And the effective date for trust can vary. For example, testamentary trusts don't take effect till after the court says it takes effect. Others can take place immediately, depending again on the terms of the trust. The trustee's qualifications. State law governs the qualifications of trustees of private trusts, not the federal government. A lot of people therefore have to be very careful. If you're a citizen, say, of the state of Arizona, you've been domiciled there for years, and you come to California for a 6-month business trip, you have to be careful who prepares a trust, because you want the trust to reflect the state law where the trust is going to be implemented. Lawyers are pretty good at it. If you give them all the facts, they will be able to do the trust in using the terms that are proper for your particular state. At least one trustee must reside in the state, with the exception of institutions as a bank or trust company, if authorized to do business in the state. Many times that trustee in the state, for example, on the Alaskan Trust, and you live in New Jersey, is of lawyer in Alaska who handles 100 of these, or it might be a professional fiduciary, but there has to be one of the trustees in the state. Again, you can have multiple trustees, obviously, and you can have different roles for each of the trustees. Limitations, well, we are not allowed to have non-U.S. citizens handle our trust, nor can we have convicted felons. Now, that might change the area of felons because, again, felons are beginning to get all the rights of non-felons, such as voting in many states. So I would not be surprised if soon even felons can be trustees. There's usually a requirement that must be age of majority. In other words, that the trustee must be of state of majority of that state. And each state has a different idea when you reach majority age. Some it's 16, some it's 18, some it's 21, some it's 16 or younger if you're married. It depends on the state. Precluded from trusteeship of private trust. Law firms cannot be trust. Accounting firms, insurance companies, businesses, corporations, professional organizations. It must be an individual who's a trust, on the trust, or a trust company could be a trust, but not a firm. So it could be your lawyer, it could be your accountant, it could be your financial planner, it could be really anyone, as long as it's not an organization. Again, the exception is trust companies and bank trust departments. They can hold that title. Most common corpus assets is cash and securities, and that's where, again, financial planners get involved, because most lay trustees, most professional fiduciaries are not qualified to control securities, and that's a major item in the trust. Therefore, they have to hire financial planners with that expertise. Less common are going to be rentals and patents. In fact, rentals might be apartment house or a summer place which is leased out. That could be a part of the corpus. Summary. In this lesson, we learned about the importance of trust in our society, especially important for financial planners and their dealings with their clients. The major role played by the trustee, lots of power and control. Legally, the trust is in their name. The public does not know who the beneficiaries are, and that has resulted, for example, in the United States being one of the countries that's very easy to hide assets because you're a beneficiary of a trust. The third item we talked about was the basic duties of a trustee, and those would be very important because it's exercising skills and caution, and finally the difference between a revocable and irrevocable trust.